As I said in the beginning of trial, and you now know, this case is called the People vs. Maya Hernandez. But we are here because of two babies. We are here because of 1-year-old Emilio and 2-year-old Mateo. We are here because on June 29th, 2025, the defendant, the biological mother of Emilio and Mateo, chose herself. She chose herself at the expense of her children. She chose herself at the expense of Emilio's life. We are here because on June 29th, 2025, the defendant chose her looks. She chose to make an appointment in Bakersfield, a cosmetic procedure. In her words, a procedure to make her feel more beautiful. That choice, ladies and gentlemen, the choice for her to feel more beautiful, to focus on herself, to focus on her looks, killed Emilio. On that day, she chose the appointment in Bakersfield. She chose to drive from Visalia to Bakersfield with her 2 children. She chose not to get a babysitter, knowing she had options. She chose to bring them to Bakersfield, knowing that she would be permitted to bring the kids into the building and they could wait in the waiting room. But what choice did she make, ladies and gentlemen, when she got to Bakersfield? She chose to leave them in the car. She didn't choose to leave them in the car while she ran inside to get milk. She didn't choose to leave them in the car while she ran to the mailbox. She chose to leave them in the car for 2.5 hours. 2.5 hours where she did not check on them one single time. And ladies and gentlemen, what was happening to Emilio while the defendant was sitting inside the building, while she was chatting with other adults, while she was socializing, while she was in a cool atmosphere? What was happening to Emilio when his mother, the one person who was supposed to protect him, the one person who was supposed to put him above all else, what was happening to Emilio as she sat in the building and ignored her responsibilities? He was burning from the inside out. His body was rising to temperatures that are not compatible with life. You heard that quotation from Dr. Thomas Riley. His body temperatures were not compatible with life. While his mother sat inside, socializing, laughing, chatting, sharing stories about cosmetic procedures, talking about her plans, talking about how hot it was outside. Emilio was perishing in the car while Mateo sat there and watched. Ladies and gentlemen, as adults, we are all entitled to make choices. We get to choose what we do on a daily basis. That's part of being an adult. But the other side to that coin is, as an adult, when you make a choice and that's a bad choice, you have to be held accountable. The defendant in this case on June 29th, 2025, made many, many, many bad choices. All of those choices benefited her at the peril of her children. It is now time for her to be held accountable for those choices. It is time for her to be accountable for leaving her 2 babies in the car, knowing it was dangerous and knowing it was irresponsible. And ladies and gentlemen, you as the jury now get to look at the defendant and tell her that her choices were wrong. That putting her vanity, her looks, her desire to feel beautiful above her children was wrong. Not only was it wrong, but it was criminal. Not only was it wrong and criminal, but she did it knowing it was dangerous, knowing it was wrong, knowing it could harm. And ladies and gentlemen, you are going to convey that message to the defendant. You are going to tell her it's time for her to be held accountable. You're going to tell her what she did was wrong by finding her guilty of the murder of Emilio and the child abuse likely to cause great bodily injury of Mateo. That is the opportunity you are going to get to have at the end of this case. After I speak with you, after Mr. Wakeman speaks with you. But in order for you to make those findings, you need to know the law. You need to know the law and how that law connects with the evidence. So I want to take some time this morning and I want to go through the evidence you have in this case. I'm going to connect that to the law in this case. And at the end of my argument, I will explain to you why the evidence, when mixed with the law, when compared to the law, is going to be sufficient for you to find the defendant guilty beyond a reasonable doubt. And I want to apologize ahead of time. You might have to hear me talking for quite a while this morning. There's going to be a lot I have to say. You might find what I'm saying to be boring at times. You might find what I'm saying or what I'm publishing to you to be redundant at times. And there will be some slides you will see multiple times. But ladies and gentlemen, as you now know, this is an important case. The evidence and the law is important. It is important that when you go into that jury deliberation room, you are fully equipped to make the appropriate decision. And I want to take some time this morning to make sure that you have the tools necessary to make the just verdict in this case. So first you have the information. Count 1, second-degree murder of Emilio. The lesser included, it shows as count 2. It is a lesser included offense. She cannot be found guilty of both. Involuntary manslaughter of Emilio. Count 3, child abuse of Emilio resulting in his death. And count 4, child abuse of Mateo. Second-degree murder of Emilio, count 1. And I'm sure, ladies and gentlemen, you can imagine the bulk of my discussion with you this morning, the bulk of my argument is going to be spent on this very charge. I'm sure you have noticed throughout the evidence that this charge is why we are here today. We are here because Emilio died at the hands of his mother. We are here because she caused his death. She did it with conscious disregard for human life, and she knew the dangers to human life when she acted. The elements. And again, as I described in opening statements, there are 2 different ways in this case, not in every case, but in this case, there are 2 different ways to get to second-degree murder. First, second-degree murder, implied malice theory. Commission of an act. The second way, which I will discuss in a moment, is second-degree murder, failure to act. First way, commission of an act. Second way, failure to act as a mother. Defendant committed an act that caused the death of Emilio. When the defendant acted, she had a state of mind called malice aforethought. Malice aforethought is defined for you in the instructions. In your instruction for this charge, instruction 520, there's going to be one single sentence that tells you what express malice is. That sentence can be ignored. This is not a case of express malice. I am not, and I will not argue to you this morning that the defendant had an intent to kill Emilio. We are here for implied malice. And implied malice means she intentionally committed the act. She intentionally left Emilio in the car. That's the act that satisfies the first element of implied malice. The natural and probable consequences of the act were dangerous to human life in that the act involved a high degree of probability that it would result in death. She left Emilio and Mateo in the car for 2.5 hours in the middle of a Bakersfield summer in extreme heats. At the time she acted, she knew the act was dangerous to human life. And ladies and gentlemen, I submit to you that I anticipate most of what this case and today's arguments are going to rely on falls right here. At the time she acted, she knew the act was dangerous to human life. You know, based upon her interviews with Detective McNabb, based upon her actions, based upon her failures to tell anybody inside of the spa that she had her children with her, that she knew her acts were dangerous, that she knew they were dangerous to human life. She got in here and she testified and she told you a different story. I will spend some time going over which of those statements is going to get you where you need to go. And she deliberately acted with conscious disregard for human life. She knew what she was doing, she knew it was dangerous, and she did it anyway. She knew it was dangerous to leave the babies in the car, but she did it anyway. She did it anyway because that day, June 29th, 2025, was about Maya. It was about Maya's wants, Maya's needs. That day was never about Emilio. It was never about Mateo. And it was never about protecting the boys. Second-degree murder, failure to protect. This one, first element, the defendant had a legal duty to protect Emilio, and the defendant failed to perform that duty, and that failure caused the death of Emilio. You will see in the instruction for this crime that a mother has a legal duty to protect. You don't have to guess on that. You don't have to speculate. That is the law. You know that the defendant in this case is the biological mother of both Emilio and Mateo. You know that it was her duty to protect as the mother, and she failed to do so. She gave you this element when she testified. She said she knows she failed to protect them. She failed to protect them because she should have brought them in with her. She should have left them with a babysitter. She should have done absolutely anything, ladies and gentlemen, other than leaving them in a car to burn and perish. When the defendant failed to act, she had a state of mind called malice aforethought. Implied malice, again, ladies and gentlemen, the same requirements for both ways to get to second-degree murder. The only thing that changes is the act versus the failure to act and the failure to perform her duty as a mother. We often hear the term malice, and in ordinary language, that sounds like a bad word. Like that sounds like we have to have hatred, ill will. No, ladies and gentlemen, not in this courtroom, not in the law. The law will specifically tell you when you're looking at Calcrim 520, malice aforethought does not require hatred or ill will towards the victim. The defendant did not have to be mad at Emilio. The defendant did not have to hate Emilio. It's okay that you saw those photographs of the defendant showing affection and loving Emilio. None of that negates the elements of second-degree murder. Nothing that you saw in those photographs negates implied malice. It's okay that she wasn't upset with Emilio. It's okay that she didn't hate him. It's okay that she did not intentionally kill him. Because none of that is required for second-degree murder, ladies and gentlemen. Now that you know the charges and the law that apply to those charges, how does that intertwine with your duties, with your job as the jury, ladies and gentlemen? It is now your job to decide what happened that day. It is your job to decide what was the defendant thinking that day. What did she know before she got out of the car? It's your job to decide that. And you decide that by taking all of the evidence you have heard, the witness statements, the testimony, the photos, the defendant's recorded interview, text messages to the nurse. You get to take all of that and you decide what happened that day. You decide what was she thinking that day. You apply that to the law. And once you do that, you come to a conclusion. And that is your job, ladies and gentlemen, as the jury. We told you during voir dire that you can't come in with special knowledge. You can't come in with your own medical opinion as to what happened. You can't come in with any preconceived notions about what happened. You can't come in with, oh, the media said this, I'm going to believe A, B, or C. But the one thing we never asked you to leave outside was your common sense. And that's because your common sense is of utmost importance in your deliberations, in your deciding what happened in this case. Do not leave your common sense in this courtroom when you go into the jury deliberation room. Take it with you and use it. How did we get here today, ladies and gentlemen? As I previously described, the defendant made an appointment to drive from Visalia to Bakersfield to receive a cosmetic procedure. Now, when she initially testified on direct, she attempted to make it sound like this was a last-minute sort of thing, that she had to come and there wasn't really much time for planning. But you learned on cross-examination that that was not the case. That she knew about this appointment for at least days ahead of time, and that she had been attempting to schedule this appointment since early May. But more importantly, ladies and gentlemen, you know that this was not a mandatory procedure. This was not a procedure that she needed for her health or well-being. This was an elective cosmetic procedure for the sole purpose of enhancing her looks and helping to make her feel beautiful. So any statements that I didn't have enough time to decide what I was going to do with him or find a babysitter, those go out the window. Because this was all based around the choices she made. This was not an emergent situation. It was not a last-minute situation. The defendant made the choice to drive to Bakersfield with the two boys, Emilio and Mateo. She knew before she left home that she could bring the boys inside the spa with her. They would simply have to wait in the waiting room. She knew that she had a stroller in her car that both of the boys could sit in, be strapped in, just like in their car seats, and sit in the spa. She chose none of that, ladies and gentlemen. She arrived in Bakersfield. She chose to go inside at approximately 2:04 p.m., and at that time, she chose to leave her children in the car. She sat inside that business in the same chair from 2:05 to 4:09 p.m. Did not move from the chair, ladies and gentlemen. You watched that. She didn't get up to check on her appointment time. She didn't get up to ask how much longer. She didn't get up to tell anybody she was in a hurry. She didn't get up to check on her kids. At 4:09, she goes back for her procedure, and at 4:33, she leaves the building. Even at this time, ladies and gentlemen, 4:33 p.m., she does not leave to go check on her kids. And you heard that through her interviews with detectives. She left to go get her phone to pay. Even when she left at 4:33, her children were not the priority. She did not leave to go get her children. She left to go get her money. Again, with Maya as the priority, not her children. After a 911 call is made at 4:40 p.m. on that day, officers are dispatched around 4:43 p.m. and arrive approximately 4:45 p.m. at the business that day. By the time officers arrive, this was Officer Velez Aguilar and Officer Fahel. Hall ambulance personnel are already on scene providing treatment to Emilio. You saw the body-worn camera, ladies and gentlemen. You saw Emilio's lifeless body on the gurney. Emilio was ultimately transported to Adventist Hospital, where he was treated by Nurse Gabrielle Long and Dr. Thomas Riley. You heard from both of those witnesses. You heard that at the scene, officers also observed Mateo. Now, by the time officers saw Mateo, he was soaking wet, he was red. A lot of that water, that soaking wet, did in fact come from efforts of Harmony and Shelby to cool him down, putting water on him, pouring water on him. But you also heard from Shelby and Harmony that before they started putting water on Mateo, he looked like he was about to have a stroke. He was hot to the touch, and he was sweaty. You heard Ian Blue describe Mateo. He said, it's a term we use in Spanish. It means kind of like wet chicken. The way he looked with his hair wet and stuck to his face when he went into the business. Mateo was also transported to Adventist Health Hospital. Emilio arrived at the hospital at about 5:00 p.m. He was ultimately pronounced deceased at 5:48 p.m. I apologize. You heard from Dr. Riley. They were as aggressive as possible in their attempts to save Emilio. They were as aggressive as possible in resuscitating him. They were as aggressive as possible in attempting to cool his body. They did cool his temperature from about 107 to 101, but that was not sufficient because it was too late. And you heard from Dr. Riley that early intervention could have saved Emilio. The defendant going out to her car to check on Emilio could have and would have saved Emilio. You heard Dr. Riley talk about how heartbreaking it was to see a 12-month-old in the condition Emilio was in. That it was gut-wrenching that he was unable to save Emilio on that day. He even said at one point, physicians are humans too. They don't put on a cloak and not have feelings. And he explained those feelings to you of seeing a 12-month-old boy come in completely lifeless. We'll talk more about his testimony in a few minutes. Mateo was transported to the hospital. While in the hospital, his temperature was approximately 99 degrees. He was fine and he was ultimately released. You heard Nurse Elizabeth Bond explain to you the difference why Mateo was okay, but Emilio wasn't. And it was because of their age. Emilio was not yet able to regulate his inside temperature because of his age. Mateo had more developed sweat glands, which explains the sweat on the outside of his body when he was located. Video surveillance. The detectives had information. The defendant told them, I left him in the car for 2 hours. She was very forthcoming about that from the start, ladies and gentlemen. The detectives could have rested on that and been like, okay, she told us. They wanted to see what happened that day. They wanted to make sure this was a complete and thorough investigation, so they got the video surveillance from the business. In that video surveillance, you can see the defendant walking up to the business at about 2:04 p.m., ultimately takes the seat by not the west door, but the door across, where she sits for the rest of the time until 4:09 p.m. At 4:09 p.m., you see the defendant get up and walk in the area that we have been told is the area of the rooms for service, room B6. You also saw that and can see that on the body-worn camera footage of Detective Barthelms conducting the measurements into the building. The defendant ultimately leaves the building for the first time at 4:33 p.m. You heard about the search of the defendant's vehicle. The infotainment screen was broken. They were not able to get any immediate information from the infotainment system about what specifically was happening in that car. There was a bottle found behind the passenger seat, right by where Emilio's seat was. And ladies and gentlemen, this might seem very minor, but it's not. You heard that the bottle found by Emilio's seat was 2/3 full. You also know that Emilio was strapped into his car seat. He could not get out. If he dropped that bottle while he was still okay, he had no liquids to drink. If he dropped that bottle after he had began to perish, he began to perish pretty quickly before he could even get halfway through his bottle. Neither of those scenarios is beneficial to Emilio. Both of those scenarios tell you that had the defendant gone out to check on them, she could have fixed the situation. You also heard that the defendant had a stroller in the trunk of her car. This also might have seemed like a fairly insignificant find when you heard the evidence. But you now know that it was not insignificant, ladies and gentlemen. This piece of evidence is not insignificant. This piece of evidence tells you that the defendant had the means to bring the kids inside with her. She had the means to literally put them the same way they were in the car. Sit each of them in their seat, strap them with the harnesses that you saw in Defense Exhibit 10, hand them the phone, and let them watch TV. Same exact condition they were left in the car. But in the stroller, they would have been inside, out of the elements, not subject to the heat, and we wouldn't be here today. But Amelia would. But the defendant chose not to use the stroller because that would have meant that she had to watch them and control them while inside the business, and that is not what she wanted to do on that day. You heard from witness Shelby Murch that she was a patron that day at the med spa. She was also waiting for her procedure. She was there approximately 30 minutes before the defendant arrived. She told you and she described for you the atmosphere in the waiting room. And you ultimately got to see the atmosphere, ladies and gentlemen, but Ms. Murch described it for you before you saw the video surveillance. And what you saw in that video surveillance perfectly matched what Ms. Murch told you. It was a friendly, welcoming, lively atmosphere. People were chatting, they were talking, there was another child. While the defendant was in the waiting room, she was bubbly and engaging in conversations with the other patrons. Bubbly and engaging in conversations with the other patrons, she told them that she had 2 little babies. She told them what her plans were for the 4th of July in a few days. What she didn't tell anybody inside of the waiting room was that her 2 little babies were actually there. What she didn't tell anybody in the waiting room was that her 2 little babies were strapped in her car. She testified, "Oh, I didn't tell them because they're strangers and I don't want to tell them about my life." But ladies and gentlemen, this is where you get to use your common sense. You know better. You know that's not why she withheld that information. She was talking to these people about getting things injected into her butt. She was talking to them about her plans. She was talking to them about the fact that she had children. Oh, but the fact that she had them with her was simply too personal? No, ladies and gentlemen. She knew that it was wrong and that it was criminal, and that if they knew, she would have a problem. That's why she didn't tell anybody her kids were with her in the car. After the defendant's procedure, the defendant left the building and went outside. Shortly after, a few minutes later, the defendant came in carrying Emilio. Emilio, who was completely limp, turning colors, his limbs just hanging. She came in and brought Emilio into the nurse's room. Shortly after that, Miss Murch saw Isabel Carrion come in with Mateo. And Shelby described to you how Mateo looked. He was gasping for air, had bubbles coming from his mouth, had peed through his diaper, sweat through his onesie, was holding an empty bottle. You also heard that he looked like he was going to have a stroke, and that when she touched him and held him, he was hot to the touch. And ladies and gentlemen, these characteristics, these observations are of the child that survived. These observations, gasping for air, bubbly mouth, hot to the touch, those are of the child that is okay. Imagine what Emilio was going through. She and Harmony took Mateo into the bathroom where they put water on him, tried to cool him down. They continued their attempts to cool him down when they brought him back out. You actually saw those attempts in the video surveillance where Shelby's holding Mateo and Harmony's patting under his clothes with the wet cloth, trying to cool him down. Then they go and rinse out his dirty milk, rotten milk probably at that time, bottle and fill it with water for him. And Shelby also told you something that was very telling, ladies and gentlemen. While the defendant was in the waiting room, she was approached and asked by another mother, the mother and grandmother combo sitting on the black couch, to watch their child while she went to the bathroom. And the defendant did. This was over an hour before, and you can see it in the video surveillance, over an hour before the defendant went into her procedure. At that time, she knew people in there were staying. They were waiting for their appointments. They were willing to help each other out. She knew she could have asked one of them, hey, if I bring my kids in here, can you watch them for the few minutes I'm in my procedure? She knew there were options. She chose not to take those options because that would have interfered with her break. At some point, another husband, wife, and another child came into the waiting room. You saw that, ladies and gentlemen. It was the man and the young boy that sat just around the corner from the defendant's chair. You also heard from Ian Blue. He went to the location with Shelby that day. They were friends. You heard from both Ian and Shelby that it was so hot outside, before they went in, they stopped at the gas station to get ice cream. It was a noticeably hot day. You heard from Ian that throughout the time the defendant was in the waiting room, there were probably about 10 people in total that came and went and were waiting. You also saw that when you watched the video surveillance. You heard from him that the waiting room atmosphere was friendly, engaging, and all the women were talking to each other. This was not an environment, ladies and gentlemen, that is meant to be serene, calm, quiet. That was not this waiting room. This was the waiting room that would have been conducive to kids. This is a waiting room that was conducive to kids. This was a waiting room that had kids in it and that the defendant knew had kids in it. You also heard from Ian, and this was the very important part of his testimony, that at approximately 3 p.m. on that day, he went outside to take his dog to go to the bathroom, Bowser. When he was outside, he was standing by the tree, right by the fence, about 2 to 3 feet from the defendant's car. And he was very clear and unequivocal when he told you, ladies and gentlemen, that that car was not running. There were no signs that that car was running, that any of the systems were running, that there was any air conditioning going on at about 3 p.m. He also told you he had no idea there was anybody inside of the vehicle. There was absolutely nothing to indicate there was anybody inside of the vehicle, and he was unable to see inside due to the dark tint. While Ian was outside, he noticed it was so hot that he had to bring Bowser back inside to get water. Ian recognized that it was too hot outside for his dog to remain outside during the same time of day that the defendant had her kids essentially locked in an inferno with rising heats. Ian thought it was too hot for his dog, but the defendant did not think it was too hot for her babies. Ian was back inside of the business when the defendant left, and shortly after, the defendant came back in with Emilio, followed by Mateo with Miss Carrion after that. And this is where Ian described Mateo as looking like a wet chicken, which is a term that's commonly used in the the Spanish language, according to Mr. Blue. Mr. Blue explained to you that Mateo looked like he was going to have a heat stroke and was gasping for air. These statements, ladies and gentlemen, they might sound redundant. Why did we have to hear the same thing from Shelby that we heard from Ian? And that's because, ladies and gentlemen, these statements show you that they're true. Two different people made the same observations and came in and told you the same thing. That is evidence. That's corroboration that what they saw actually happened. Their testimony is supported by other testimony, other evidence. And while Ian was on the stand, he talked about some of the conversation that was happening inside of the business. He told you, ladies and gentlemen, that when the man and his son came in, there was a statement made that they had to come in because it was simply too hot to wait outside. This statement was made in the same vicinity, in earshot of the defendant. You know this because Mr. Blue specifically told you that he interpreted for the man and he repeated the statement loud enough for everyone in the room to hear. Not only was this statement made, ladies and gentlemen, there was a conversation that followed. A conversation whereby the people in the waiting room started almost joking about the fact, yeah, imagine how hot it is outside with how warm it is in here, and we have some air conditioning. Those conversations, ladies and gentlemen, took place with the defendant while her kids were trapped in the heat. Even those conversations did not make the defendant think, oh, I should probably go check on them. It is pretty hot. She heard the statements, and much like everything else she did that day, she ignored them as they related to her children. She ignored her children. She did not check on them, even though other people came in and were talking about how hot it was outside. Then you heard from Ms. Isabel Carrion, Harmony's assistant. She told you that the defendant came in that day for a treatment to her buttocks area. You later learned it's referred to as a liquid BBL, a liquid Brazilian butt lift. Injections into somebody's butt to enhance the appearance. She's the assistant. After the defendant's procedure, she did not pay right away. She said she had to go to her car to get her phone. Some time had passed. Ms. Carrion was concerned that the defendant was going to leave without paying, so she went outside. Her car, her BMW, the white one in the photograph, was parked directly next to the defendant's. When she got to the car, she saw the defendant holding Emilio and moving him upside down. Not on the phone with 911, not giving CPR, not trying to get help, moving Emilio up and down in the car. This action, ladies and gentlemen, came after, from what you heard from Detective McNabb, that the defendant walked towards the business and then back out. Again, that might seem like a small piece of evidence, but think to yourself, she obviously started walking towards the business because she thought perhaps she could get help. And then realized, but then they're all going to know that I have my kids with me. They're all going to know that I left my kids in the heat in the car. That's not going to look bad, or not going to look good, I apologize. So she turns around and walks back to her car. About 2 minutes later is when Ms. Carrion comes out, sees her in her car, tells her, you need to go get help. Your baby is not okay. At that point, she goes inside, subsequently comes back out and calls 911 at 4:40 p.m. 6 minutes passed in that time period, ladies and gentlemen. Think about 6 minutes and how long 6 minutes truly feels. And you're going to see how long Emilio sat there again without getting the help he needed while his mother, his protector, was trying to figure out how to cover up her actions. You heard from Ms. Carrion that the defendant was not showing any urgency, was not screaming, was not asking for help. Ms. Carrion only knew Mateo was in the back seat because she saw him due to the rolled down passenger side window. The window that was only rolled down after the defendant went back outside. The defendant did not tell her, help my other baby. She just took off with Emilio inside. Isabel saw Mateo in the back seat. She described Mateo as too hot. His skin was red, and flushed all over. He was weak and drenched with sweat. She also described the inside of the car. She initially said that it was hot, very hot. And then she agreed that she had actually told Ian, and I apologize for my language, ladies and gentlemen, but she had told Ian that when she reached her hand in the car to get Mateo, the inside of the car was hot as hell. Compare that statement, ladies and gentlemen, to the defendant's description of inside the car during her interviews with detectives. Compare that, the statement of Miss Carry-On, who has no reason to embellish, no reason to exaggerate, to the defendant who said, it was pretty comfortable. When you know, ladies and gentlemen, that there's no way, shape, or form that vehicle could have been comfortable at that time. Ms. Carry-On told you that when she got into the car to get Mateo, the car was not running. The air conditioner was not on. Those also contradict the defendant's statements. And again, ladies and gentlemen, and I will encourage you, when you are considering what statements are credible, what statements to give the most weight to, take out Calcrim 226. Put that on your desk while you're thinking of the witnesses. And ask yourself, well, did Shelby, Ian, Harmony, who we'll get to in a second, Isabel, did they have any reason to lie? Did they have any reason to exaggerate? Did they have any bias or interest in this case? Those are things that are outlined for you in 226, things that you get to consider. And the answer to all those questions is going to be no. These are people who did not know the defendant until that day. They didn't know her before, they don't know her after. They were there for some cosmetic treatment and really ended up in a horrible situation. A horrible situation that is probably going to impact their entire lives. So when you are looking at what these people said and you're comparing it to what the defendant said, then ask yourself, well, did the defendant have reason to lie? Absolutely. Did the defendant have reason to downplay? Absolutely. Did the defendant have a personal interest in how the case is decided? Absolutely. Does the defendant have a bias in this case? Absolutely. You take those two statements, you take the inconsistencies, and when you use those with Calcrim 226, you are going to find that you have to believe and give credence and credibility to Harmony, Isabel, Shelby, and Ian long before the defendant. You heard from the nurse, Ms. Pacheco. She explained to you that she is an aesthetic injector. She provides cosmetic procedures to help enhance appearances. These procedures are not medically necessary. Certainly the procedure that the defendant was receiving that day, the liquid Brazilian butt lift, was not medically necessary. These are things to make people feel beautiful. They are elective chosen procedures. She told you that the defendant's procedure took about 15 to 20 minutes. That's consistent with what you saw in the video surveillance. She told you that during the morning hours of June 29th, 2025, she told the defendant that she could bring her kids in. You saw those text messages, ladies and gentlemen. You have them with you in the back if you want to look at them again. That conversation, you know, from both the defendant and from Ms. Pacheco happened before the defendant left Visalia that day. Ms. Pacheco told you that the defendant told her she had to go get her phone from her car because she left it in there because it was dead. The defendant told you that was a lie. That was not what she told Ms. Pacheco. So again, ask yourself, what reason did Harmony have to make that up? Absolutely none. And also look back at her testimony and consider how that testimony came out. She didn't come in here and say, yeah, she said it was dead and that's why she went out and now I know she's lying. She actually couldn't remember right away if that is what the defendant said. She refreshed her memory with the transcript of the statement she gave on the date of the interview. She didn't come in here with any malice. She didn't have an agenda. She was just testifying to you what she saw and what she observed on that day. She saw the defendant then come back in with Emilio. Emilio was limp, purple, and foaming at the mouth. Again, common descriptions throughout, ladies and gentlemen. When she saw Emilio, she told the defendant to call an ambulance because it was clear that he was not okay. And shortly after that, she saw Isabel come inside with Mateo. She said Mateo looked very hot, was hot to the touch, and his heart was beating really fast. This is an important statement, ladies and gentlemen, especially in light of what you heard yesterday from Dr. Thomas Riley. Harmony Pacheco, a registered nurse, told you that she felt Mateo's heart rate and it was beating really fast. Yesterday, Dr. Thomas Riley testified. He testified in the context of Emilio. He was a doctor for Emilio. But he also told you that hyperthermia, one of the things that happens when somebody's body is going through that, is their heart begins to beat really fast, essentially until it gives out. So you know that this statement is consistent with what could have been happening. And that Mateo might not have been as bad as Emilio, but he sure was on his way had he not been caught when he was. Based on Mateo's appearance, she took him to the bathroom where she put water on him. She then started putting wet cloths on his body to try to cool him down because he looked like he was going to have a stroke. His bottle, was empty and appeared that it had old milk in it, so she had Isabel rinse it out and put water in it. Again, ladies and gentlemen, you know it was old milk because the defendant testified in court and told detectives that she had left each child with 1 bottle of milk. 1 bottle of milk for 2.5 hours, including the drive from Visalia to Bakersfield. Then the text messages, you'll have those in the back with you. They just confirm the conversation. Then you heard from Nurse Gabrielle Long. She was the treating nurse to Emilio. She told you that Emilio's temperature was 107 degrees when he came in on June 29th, 2025. And ladies and gentlemen, I want you to consider something very important when you think about the testimony of Gabrielle Long, Elizabeth Bond, and Dr. Thomas Riley. These are medical professionals who, by their own testimony, see emergencies all day, every day. Not a single one of them had to come in here and reference any documents as to this incident. Not a single one of them had issues remembering Emilio or Mateo from that day. You heard Gabrielle Long tell you that she had never seen a temperature that high in her career. She also told you that Emilio's temperature was likely higher when he was in the car before he had been exposed to the airflow outside, exposed to the air conditioner in the ambulance, and transported into the hospital. Nurse Elizabeth Bond, she provided treatment to Mateo. She came in here and told you that Mateo was fine. He was responsive, he was okay. The one thing she noticed that was interesting to her was that Mateo was very clingy to the hospital staff. And she said, this is weird because most children don't want to be around us. Most children go away from us. He was clingy, he wanted to be held. He wanted to be comforted. And why is that, ladies and gentlemen? Because that day, just before he met Elizabeth Bond, he had been abandoned. He had been abandoned by his protector, by the person that's supposed to protect him. He sought out comfort in strangers because he didn't get that from his mother. She explained to you that the difference between Mateo's temperature and Emilio's, again, can be explained by their age, the body's ability to release sweat, regulate its temperatures as the body gets older. Dr. Thomas Riley, you heard from him yesterday. He's been an emergency room physician for 30 years. You saw how he testified, ladies and gentlemen. When he was talking about Emilio, there were times when he appeared he was going to get emotional. He talked about the lengths they went through to try to save Emilio. That Emilio suffered from cardiac arrest in the field. When he came to the emergency room, he was intubated and they were doing resuscitation efforts. When Emilio arrived, he was pale, ashen, cyanotic, meaning purple or hypoxic, not getting air, no oxygen flow to his body, Emilio was literally lifeless, is a quote from Dr. Riley. Literally lifeless. He and other ER personnel attempted life-saving measures for at least 40 minutes. When Emilio arrived, his temperature was 107 to 108 degrees. They took steps to cool him down, including ice packs all over his body and a cooling IV. He described these as being as aggressive as they could to try to save Emilio. He told you that a temperature of 107 is not compatible for life. Someone cannot live. A body cannot sustain that temperature. Heart rate fluctuation caused by temperatures cannot sustain life. Dr. Riley explained to you that being exposed to extreme heats for an extended period of time causes the organs in the body to be impacted, causes a chemical breakdown of the cells. And he described to you that when this organ failure is happening, this breakdown of the cells is occurring, that person experiences these things. The person going through this begins to have an overwhelming sense of heat. They may begin to become overwhelmed and hyperventilate, feel like they are suffocating. He said this person can feel like they are being strangled, all from being exposed to the heat. He also told you that Emilio had signs of rigor mortis, stiffening of the muscles in the body as a result of the body shutting down. And that rigor mortis typically begins to set in within 1 to 2 hours. Emilio's organs and his body had already shut down at least 1 to 2 hours before Dr. Riley had ever seen him. Probably the most important sentence you heard from Dr. Riley: early intervention could have saved his life. Early intervention could have saved his life, ladies and gentlemen. And there is one person in this world that could have gotten him the early intervention. One person that knew he was in the car. One person that had a legal duty to him. One person that was obligated to check on him and get him that early intervention. The defendant, by simply going to check on Emilio, could have prevented all of this. But she, again, chose not to. Early intervention could have saved his life. But the defendant did not allow for that to happen. He told you how heartbreaking it was to see Emilio, how gut-wrenching it was when they could not save him. And then you heard about the recreation. Again, kind of like the video surveillance. Detectives wanted to ensure they took steps to make this as thorough as possible. And Detective Barthelmess, well, we don't know what was happening that day. We don't know how it felt inside the car. Let's try to find out. Let's simulate that day as best as we can. So they looked up temperatures. They found a date that had temperatures almost identical, at times identical, to the date of June 29, 2025, and that was July 2nd. They got the car, they ran the car for an appropriate amount of time. They took the defendant's car to 31 South Real Road. They parked the car in the same exact parking spot and made sure to arrive in the parking lot at the same time the defendant arrived. And ladies and gentlemen, it's also important to keep in mind that during this recreation, you were informed, you were told they did the recreation in a light most favorable to the defendant. They took her for her word at what she said she did that day. And they did the recreation as such, which meant they stayed in the car for a little while. They used the same times. They used the same parking space. They ultimately got out of the car at about 2:09, shut the doors, locked everything up, and left the car. They left the car with thermometers that had been appropriately calibrated, thermometers that were working, and body-worn cameras to capture the temperatures inside of the car. You also heard that at 4:08 p.m., Detective Jordan's body-worn camera shut off. Could not record anymore. At 4:16 p.m., Detective Barthelmess's camera, which was on Emilio's seat, shut off at 4:16 p.m. Both of those cameras gave the same notice: critical internal temperature. The car got too hot for an electronic device. It was too hot to sustain an electronic device while Emilio and Mateo were still strapped inside of it. You have Exhibit 75, and that is the item that was judicially noticed by the court, that the temperatures in Bakersfield on June 29th, 2025 at 2:54 p.m. was 101 degrees Fahrenheit. At 3:54 p.m., 102 degrees Fahrenheit. And the high temperature that day was 102 degrees. The high temperature that day occurred while Emilio and Mateo were inside of the car. The temperatures in Bakersfield on July 2nd, 2025, the date of the recreation, 2:54 p.m., 101 degrees. Identical to the date of June 29th, 2025. The temperature at 3:54 p.m. on July 2nd, 2025, 101 degrees. 1 degree cooler, actually, than the date of the actual incident. The high on July 2nd, 2025 was 101 degrees. And again, we just went over this, the steps that the detectives took to make the recreation as identical, as similar to the date and issue. Rolled up the windows, shut the door, left the AC running as the defendant described, and that is a setting 4 out of 7 at 60 degrees. With one air vent in the car, ladies and gentlemen, an air vent that the defendant told you was only in the front of the car. Now, I say they did it as the defendant told them because I anticipate, and you have heard, there is statements from the defendant that she left her air conditioner running, that she left her car on. And I urge you, ladies and gentlemen, to accept those statements with caution. Take those statements in light of CalCrim 226. And recognize that although the detectives considered that information in doing the recreation, that is not indicative that they were taking that statement to be true. They were simply conducting the recreation in a light most favorable to the defendant. You do not have any independent evidence that that air conditioner was left on or how it was running at the time. The only evidence you have of any air conditioner came from the defendant, and we'll discuss that in a few minutes. Detective Barthelmess specifically told you the questions they wanted to answer with the recreation. Does the engine shut off after an hour as indicated in the owner's manual? The owner's manual that the detectives bothered to look at, but the defendant never did. The defendant specifically told you she never looked at the owner's manual, doesn't even know if she ever had one. That was in her testimony on direct examination. That could have provided her some useful information when she chose to leave her kids in the car, but she didn't care. What was the internal temperature of the vehicle when defendant left Mateo and Emilio inside of the vehicle? If the vehicle does shut off after an hour, how long does it take the internal temperature to rise? What is the maximum temperature inside of the vehicle once the vehicle is shut off? How long were Emilio and Mateo exposed to these temperatures before defendant returned to the vehicle? And guess what, ladies and gentlemen? They got answers to every single question they had. The car did, in fact, shut off after 1 hour, as indicated in the owner's manual. Even with the air conditioner set as described by the defendant, the coolest Emilio's seat ever got was 80 degrees. And that's because by her own statement, if to be believed, she left it on the middle setting with an air vent only in the front seat. The air wasn't circulating to the back seat. Emilio and Mateo were exposed to temperatures of over 100 degrees for over an hour before the defendant returned to the vehicle. Emilio's seat reached ambient temperatures of 116 degrees. And I say ambient temperatures, ladies and gentlemen, because that is the temperature that came off the thermometer that was essentially hovering in the middle of Emilio's seat. But you heard from Detective Chad Ott that the temperature in Emilio's seat as he was sitting in there was likely significantly higher due to his body being in the seat and his body heat going into that area. Temperatures inside the vehicle. Again, ladies and gentlemen, you have this. You'll have it in the back with you. Was testified to, and it is part of the video surveillance. But the car hit 100.5 degrees at 3:25 p.m. By 3:30, had jumped to 103 degrees. By 3:35, had jumped again to 105.2 degrees. By 3:40, had jumped to 107 degrees. By 3:55, jumped to 110.6 degrees. 4:05, 112.4 degrees. 4:15, the last recorded temperature by body worn camera before it died because of the heat, 114 degrees. And the temperature when detectives opened the doors at 4:33 p.m. was 116 degrees. You'll have the photos of the thermometer. You'll have the video of the temperatures rising. You saw it in court. It was boring. Some might even describe that as painful. But you know what, ladies and gentlemen? You got to watch those temperatures rising in the air-conditioned courtroom. Emilio and Mateo experienced that in real time. They experienced those temperatures rising with nowhere to go, nowhere to escape. You got to have the air conditioning, your bottles of water. I believe we even interrupted to take a short break at one point. Consider how painful that was to watch. And Emilio and Mateo had to experience that in real time. You heard from Detective Chad Ott. You heard about his background, his science. He told you about studies he's participated in, studies he's read. Studies he's read in relation to recreations in babies left in hot cars. And he actually told you that he found the results of Detective Barthelmess' recreation to be quite favorable to the defendant. And he said that based upon the studies he read. For example, one study had to do with temperatures, external temperatures outside of 73 to 93 degrees. And the internal temperature of that car rose to 135 degrees, ladies and gentlemen. Detective Ott told you that the manner in which the recreation was conducted was scientifically sound, that it was done in the way to best achieve the most accurate results. And he even told you that he was quite impressed by the amount of effort that had been placed into recreation. He was impressed by the steps the detectives took and thought about to make this recreation as accurate as possible. And then again, the video surveillance. Ladies and gentlemen, we sat through that video surveillance. About 2 hours in court. There wasn't sound, there wasn't talking. Almost the entire time, we watched the defendant sit in one single chair. Again, it was boring. We might even call parts of it, most of it, or all of it painful. But again, ladies and gentlemen, you experienced those 2.5 hours in the comforts of an air-conditioned courtroom. Emilio and Mateo, they experienced those 2.5 hours trapped inside of a hot car during the hottest time of day. And I say trapped because they had no way to get out. They had no means to get help. They were trapped in an inferno, ladies and gentlemen. So yes, it was painful to sit there for 2 hours, but you had water, you had air conditioning, you had airflow throughout the courtroom. Emilio and Mateo did not get that same courtesy from their mother. And this is just a kind of a combination of the video surveillance with the recreation, where you can see the defendant sitting inside the business, chit-chatting, engaging, laughing, smiling at different times when her vehicle is 105.2 degrees outside, 107 degrees outside, sitting there, legs crossed, arm on her chin, and not a care in the world. Her car with her 2 children is 107 degrees, best case scenario at that time. 108 degrees, still sitting there chatting, not a care in the world. 109.5 degrees, still sitting there, legs crossed, chatting, looking at the other patrons, having a conversation. 110.6 degrees, still sitting in the same chair. Cool. Access to the bathroom, water if she needs it, talking to the other patrons. 111.5 degrees, bent over, engaging in conversation, sitting in the same chair. 112.4 degrees, still just sitting there, chatting, perhaps talking about their BBLs, their 4th of July plans, while her kids are burning in her car. 113 degrees is when she essentially gets up. She doesn't leave. She's gone from that chair. But at this point, she goes back into the treatment room. Down the steps, down a hall, down another hall. Still in the business. When her car's getting up to 114 degrees. She starts walking out at 4:33 p.m. She's walking out of the air-conditioned building while her car is a temperature of 116 degrees. And she's walking out not to go check on the kids, but to go get her phone to pay for her treatment. You heard Dr. Glineski testify about the autopsy. He performed the autopsy of Emilio. This autopsy took place on July 5th, 2025. And he explained to you that Emilio had edema, or commonly referred to as swelling of the brain. The brain swelled, and it continued to swell and swell until it began to shut down. The shutting down of the brain caused the rest of the organs to begin to shut down. He also told you that somebody going through this edema, swelling of the brain, can feel it within their body. They experience it. This is not a quick death, ladies and gentlemen. This is a slow, painful death where the person begins to feel lethargic. They begin going limp, perhaps unable to speak. They lose the bodily functions. They may urinate, may defecate on themselves because the organs preventing all of that are no longer working. This person might start having seizures and will likely show foamy secretions, all things that were present with Emilio. Dr. Glineski explained to you that the body begins to shut down at 104 degrees. But when Emilio arrived to the hospital at 5 p.m., his temperature was 107 degrees, which is probably lower than it was in the car. Emilio's body began shutting down a significant amount of time before he was found by his mother or by the ambulance personnel. Dr. Glineski, in addition to Dr. Riley, told you that it is impossible to survive a temperature of 107 degrees. Dr. Glineski, impossible to survive. Dr. Riley, that temperature is not compatible with life. The cause of death was hyperthermia, commonly referred to as heat stroke. And this is where his testimony got interesting, ladies and gentlemen. He told you that he initially, and he wrote on the death certificate, that the manner of death was an accident. But he explained to you why he made that finding. And he said, I hate making findings like this because I have to do it based upon just a little bit of information. Just the information that his investigator provides to him. He told you, I was 50-50 on accident versus homicide. And again, ladies and gentlemen, it's important to recognize and consider these are medical terms. Medically an accident, medically a homicide. This is not a legal term. It is not a legal definition for you to consider. You are the judges of whether or not this was legally murder, legally homicide. These are medical terms. Homicide meaning the death at the hands of another. He told you he didn't have enough information about the defendant's intent or mind state. He didn't have her recorded interviews. He wasn't able to watch those. And he told you that his opinion would likely change were he to find out that she knew it was dangerous and she did it anyway. He was 50-50 before he had information on whether or not the defendant knew the dangers and acted anyway. So he said accident, but he told you that this likely could have been a homicide as well, medically speaking. Now, let's talk about the defendant's interviews, ladies and gentlemen. You will have these interviews with you. You will have them in the back. You can watch them. And as you heard in opening, and as I told you today earlier, and you probably gathered through the course of the evidence, the crux of this case, the crux of your decision is going to be, what did the defendant know and when did she know it? Her interviews, both her first interview on June 29th and her second interview on July 3rd, give you those answers. She admitted to coming to Bakersfield, leaving the kids in the car, had the kids strapped in the car. Those items of evidence, ladies and gentlemen, are uncontested. Nobody's arguing those. Nobody's saying they didn't happen. But one thing she did say in her first interview was she did not know how long she left the children in the car. But you know, after watching the video surveillance and hearing her testimony, that she did know how long they were in the car. She knew how long she was in the business. She was wearing an Apple Watch. Between 2:27 p.m. and 4:08 p.m., she checked her Apple Watch no less than 45 times. She knew how much time was passing. She knew she wasn't just going to be in there for the quick 15 to 20 minutes. She knew that after the first 20 minutes. She knew that after the second 20 minutes. She knew that after an hour passed. And at 3:33, ladies and gentlemen, the nurse specifically told her there was still another person ahead of you. At 3:30, and almost an hour and a half of having been in the business, she knew it was still going to be probably another 40 minutes. And she continued to sit in that chair without any actions. She said in her first interview that she left her phone with her kids because they were watching TV. That she propped it up on the headrest so that they can see it while they were sitting in their chairs with their cookie, their one bottle of milk, and their candies. In her second interview, she tells detectives that she didn't bring the kids inside because they were sleeping and she didn't want to wake them up. So were they watching TV or were they sleeping, ladies and gentlemen? These might seem like small inconsistencies, but it's the inconsistencies that tell you whether or not she is being completely honest. Whether or not she's being completely honest with the detectives, and whether or not she was completely honest with you in court. She estimated she was in the waiting room for about an hour. You know that's not true. She knew that wasn't true. She admitted that she did not go to check on the boys at any time. She told you that when she went back to her car, the car was still running. You know from Ian's testimony that that's not accurate. You know from Isabel's testimony that that's not accurate. You know from the recreation that that is physically impossible. Isabel told you that it was hot when she got back to the car. It was not on. The AC was not running. It was hot to the touch. She told you that Amelia was hot to the touch, that Mateo's cheeks were red. That's what alerted her that something was wrong. Those statements, those observations are not consistent with her statement that her car was still running, that her air conditioner was still on. And she says, it sounds stupid for me to say, I didn't mean for that to happen because, I did leave them, but I thought they were going to be okay. It sounds stupid for me to say. Why did she say it that way, ladies and gentlemen? It sounds stupid for me to say I thought they were going to be okay because I know better. It sounds stupid for me to say this because everybody knows better. Then she says that she knew her sister would probably say yes if she asked her to watch Mateo and Emilio, but she didn't want to irritate her. That statement was also different than how she testified on the stand. We'll talk about that in just a moment. Then she testified on the stand that her concern was not that the kids would be running around in the waiting room. Her concern was that they were sleeping. But in this first interview, just hours after the incident, ladies and gentlemen, about 8:25 p.m. on June 29, 2025, she says, Detective McNabb asks her, so your concern was they'd be running around the waiting room without you? She said, yeah. Your concern is they would be running around, which is why you didn't bring them in? Yeah. But now you know she had a way to prevent that. She had her stroller. She could have buckled them in their stroller. She did not ask about Emilio's condition until 30 to 40 minutes into the interview. Right as the detectives were telling her they were going to take a break, she asks about Emilio's condition. Why did she wait that long to ask? Because she already knew. Because she knew what she did. She knew before she did it, it was dangerous. And at that time, she knew everything had come full circle and the dangers she knew existed actually happened. She said that she knew that leaving the children in the car was a bad decision, acknowledged that her story about the air being on did not make sense when considered with all of the evidence, told Detective McNabb that what she did was irresponsible. She told Detective McNabb that she thought about the fact that it was irresponsible when she got out of the car and left the babies inside. She told you yesterday, ladies and gentlemen, that she didn't realize it was irresponsible until after the fact. June 29, 2025, 8:25 p.m., thought about the fact that it was irresponsible when she got out of the car and left the babies inside. That's implied malice murder, ladies and gentlemen. That's an admission to knowing it was dangerous and acting anyway. Detective McNabb, you know have you heard the radio ads about not leaving your kids in the car? I mean, a lot of cars nowadays, when you get out of the car, they tell you to make sure to check for your kids. Like it's, that's kind of an irresponsible thing to do. Defendant, yeah. Detective McNabb, I mean, do you know that? Defendant, yeah. Detective McNabb, okay. Did you think about that when you were getting out of your car? Ladies and gentlemen, these questions could not be more clear. Did you think about the dangers when you were getting out of your car? Defendant's answer, yeah. So this storyline that you heard yesterday, that she didn't realize it was bad, dangerous, or irresponsible until after the fact, you cannot believe that testimony, ladies and gentlemen. You cannot compare that testimony and her incentives to lie, her reasons to lie, with the statements she made to Detective McNabb under completely different circumstances and believe her in-court testimony. You cannot. It doesn't work. I mean, Detective McNabb, if you knew that and you thought about it, what made you think it was okay to leave him? I don't know. Well, ladies and gentlemen, if she was truly misunderstanding what Detective McNabb was asking her, as she wants you to believe, when he's asking her, what made you think it was okay to leave them, her answer is, oh, because beforehand I didn't realize it was bad. I'm sorry. I misunderstood you, Detective. I now understand it was bad. I now understand it was dangerous. I didn't realize you've been asking me about what I knew beforehand. That's not her answer. That was never her answer. And look at this recording. Consider this recording, ladies and gentlemen. She is not confused by the questions. She does not have to ask the detectives to repeat their questions. She understands what she's being asked and she answers them directly. And now we're moving on to the defendant's interview number 2. Some more statements that show you that this is exactly second-degree murder. Detective McNabb, but I do want to just talk a little bit about what you were thinking as this was going on, okay? There's a lot of talk in have you ever heard like the radio ads about not leaving your kids in the car? You have? Question mark. Watch the video. He says you have with a question mark because she's nodding her head. What did you think could happen if you do leave them? Like prior to this happening, did you understand? Prior to this happening, did you understand? Clear as can be as to the timing the detective is talking about, ladies and gentlemen. And I understand the circumstances are different, but what do you think could happen if you left your kids there? Defendant, what happened, I guess? Then he follows up. What happened with Emilio? Question mark. Did you know that prior to this happening? Completely unambiguous question, ladies and gentlemen. He does not say, do you know this? Do you know this now? Is this your current understanding? He says, did you know that prior to this happening? Defendant responds, I seen the news and stuff, but I didn't really think that would happen. I knew it can happen, but I didn't think it would happen to me. You saw the news? Like, have you seen news of this happening before? I mean, not actually, but I've heard people talk about it. Is there anything specific come to mind or just in general? Just in general. I knew this was bad in general from hearing people talk about it because everybody knows it's bad. This is information, ladies and gentlemen, that this day and age you cannot avoid. You cannot avoid knowing that leaving babies in a car can result in death. Everybody knows that. It's in the news media all the time. It's in ads all the time. Okay, did you think about that as you were getting out of the car? Again, another opportunity for the defendant to say, oh, you've been asking me if I thought it was dangerous before I did it? Let's back up, detective. I thought you were just asking me about if I knew it was dangerous now. This is yet another opportunity for her to say, oh, I've been misunderstanding you. But she doesn't, because she knew exactly what they were asking about. She says, I thought it's not like I just left them in there for him to fucking die. That's her statement, ladies and gentlemen. That's from the defendant's mouth when she's being asked about the dangers that she knew. After telling detective multiple times that she knew it was dangerous, that she knew what could happen, that she knew that what could happen to Emilio, him dying, could happen if she took her actions. I want to know your thoughts, or what thoughts crossed your mind. You said it was irresponsible. Defendant, yeah. Detective McNabb, and I don't think anybody, that's cut off, I apologize. And then defendant, but they were sleeping. I didn't want to wake them up either. I didn't want to wake them up either. What does that one word, ladies and gentlemen? I didn't want to wake them up either. I thought about the options. I thought about the potential consequences. But I also didn't want to wake them up, so I let them continue to sleep, if they were sleeping to begin with. But I didn't want to wake them up either. One word, ladies and gentlemen, can tell you almost everything you need to know. She thought about the consequences, she thought about her choices, and she chose the choice that most benefited herself. It was a lot of time in the hot car, and obviously I don't want to beat around the bush here. Obviously, you know damage can happen from that. Defendant, and in the video, she nods her head up and down. Then you have the phone call with Rosenda Gutierrez, the father to Emilio Mateo, that defendant testified about yesterday. You know you did was wrong, don't you? Obviously. Rosendo, huh? Defendant, obviously, I'm not an idiot. She's not an idiot, ladies and gentlemen. You heard Dr. Masako tell you yesterday she's not an idiot. Very average IQ, much like most of us in this courtroom. I'm not an idiot. Of course I knew it was wrong because I'm not an idiot. Only an idiot wouldn't know that you can't leave your kids in the car in the heat. That's what this says. I'm not an idiot. Obviously, I know it was dangerous. Obviously, I knew that. And again, we touched on this earlier. I'm going to go into the defendant's court testimony in just a moment. As I discuss with you the statements made by the defendant, as you consider the defendant's testimony while you're in the back, consider CalCrim 226. That is the instruction that the law tells you the factors you can use in evaluating and judging a witness's testimony. And this is important, ladies and gentlemen. When the defendant decides to take the stand, she is to be given the same weight as every other witness. She does not get extra points because she didn't have to testify. She does not get extra points because she is the defendant. Once she takes that oath, she is a witness the same as anybody else. And ladies and gentlemen, you have heard about the presumption of innocence. The defendant is presumed to be innocent. She is not presumed to be honest. She is not presumed to be trustworthy. So when you consider her testimony, consider these factors. Did the witness understand the questions and answer them directly? You heard multiple times during cross-examination where I asked her a question, she answered initially and then added extra to the end. She understood the question, but she wanted to make sure she got her version of the answer out. Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is decided? Ladies and gentlemen, the defendant, the witness you saw yesterday, the witness Maya Hernandez, is the only witness you heard from in this case that has a personal interest in how this case is decided. She's the only witness that has bias. She's the only witness that has reason to be untruthful. Next, did the witness make a statement in the past that is consistent or inconsistent with her testimony? This kind of goes hand in hand with the factor above. Was she inconsistent in the past? Yes. What does that tell you? That tells you that maybe she's not being honest with you. That tells you that maybe those biases, maybe her interest in how the case is decided is sneaking through from that stand. Those inconsistencies, different statements when she's testifying than what she said to Detective McNabb, those show you that she's not being honest with you, ladies and gentlemen. How reasonable is her testimony when you consider all of the evidence in this case? The thing with her testimony, ladies and gentlemen, is you can consider how unreasonable it is by only considering it against two other pieces of evidence. You can take her testimony in court and simply compare it to her two recorded interviews and know right off the bat exactly how unreasonable it is. But then when you start adding all the other evidence into the case, it blows her testimony out of the water. When you consider everything, including her own prior statements, you're going to see that her in-court testimony was not reasonable. Did other evidence prove or disprove a fact about which the witness testified? Absolutely, including her own statements. So let's talk.
I'm sorry, we need to take a break.
Yep. And I just want to remind you that CalCrim 226, which will be in your packet of instructions, is going to be very helpful to you in how you decide to evaluate the defendant's testimony in court. So first, we heard from the defendant that she made an appointment for a liquid BBL in Bakersfield for the date of June 29th, 2025. You heard at the beginning of her testimony on her direct examination, she attempted to kind of characterize this as a last-minute type of appointment that she didn't have prior notice of. But then you heard on cross-examination that she did in fact know about this appointment for many days ahead of time and that she had been working on scheduling this appointment since early May. Plenty of time to make arrangements for her children. Chose not to. She told you during her testimony that she had asked her sister to babysit, and her sister said no. Again, this is another one of those things that might sound fairly insignificant, might be a small point to make, but it shows you that she was not being honest with you. Because you heard in her testimony, or her interview, I apologize, with Detective McNabb, that she specifically talked about her sister and the potential of her sister babysitting. And she specifically says, I know if I asked her, she would say yeah, but I mean, like, I know it irritates her. That is not, I asked my sister and she said no. That is, I knew that was an option, but I didn't want to annoy her, so I chose not to take that option. That's evidence of a lie, ladies and gentlemen. You heard that she took both of the boys with her from Visalia to Bakersfield for the appointment, that she knew before she left Visalia that she could bring the boys inside with her. She didn't bring the boys in with her because they were sleeping. Now, this is consistent with her second statement to law enforcement, but it is inconsistent with her first statement as well as her other testimony in court. And that is the fact, ladies and gentlemen, that she left the TV on for them. If they were sleeping and you don't want to wake them, turning on their favorite show, Paw Patrol, probably is not the appropriate route you want to take. The story that they were sleeping does not fit with the other evidence or the actions that the defendant herself said she took. She also said when she testified that one of her concerns was not the fact that the boys might be running around the lobby while she was in getting her appointment. But you saw, and you can see again if you choose to watch it while you're deliberating, her recorded interview where she does say her concern was that they would be running around. You also now know that there was a solution to that should she have chosen to take it. She told you that she got out of the car about 2 p.m. and went into the business at 4:33 p.m. And it's important, ladies and gentlemen, that you look at these consistencies, and when you look at what she admitted to in court, look at those admissions and compare them to the physical evidence. She admitted, and she was consistent with the things that there was evidence completely showing her to have been doing. This was thought out testimony. Again, she's not an idiot. She's a smart girl. She knew what she was doing, and she knew what her plan was. She knew what her plan of attack was for her testimony. I'll admit to the things that I can't fight. I'll admit to the things that aren't that relevant. But I'm going to deny the issues. I'm going to deny my knowledge. I'm going to tell them I misunderstood. These were planned actions. This was planned testimony. And I think that came off very clearly throughout her testimony. She admitted that she never left to check on the boys. Again, that's going to be very hard to dispute based upon the video surveillance we watched in court. Acknowledged that she was checking her watch throughout her time in the business, and that her watch did in fact display the time when she was looking at it. Left her phone in the car for the boys to watch Paw Patrol, and again didn't bring the boys in because they were sleeping. This is not consistent with watching Paw Patrol, leaving candies and cookies with the boys. And also she admitted to leaving the boys with 1 bottle of milk each, no water. She said that she thought the air conditioner would stay on while she was in the business. And ladies and gentlemen, again, I'm going to point out one word that I want you to pay close attention to. Every time you heard the defendant mention leaving the air conditioner on, she used the word, I thought it would stay on. Never once did she say, I knew it would stay on. And that is because she didn't know that. Because she had never read the owner's manual. She thought it would stay on, and that thought was wrong. But thinking that the air conditioner would stay on and thinking that that would make her actions okay also tells you that she knew it was wrong and dangerous to leave them in the car in the first place. Or else she wouldn't have to reiterate these actions to you. She told you that she did not know if it had stayed on because, again, she never went to check on the boys. She never went to check on the car. She never left the business. She knew she was inside of the business for a long time, And at 3:30, she had confirmation that it would be at least another 20 to 40 minutes before her procedure. So even painting this in the light most favorable to the defendant, at that time, she could have thought, well, I'm not going to miss my appointment, so let me go check on them. But she didn't. Because at no point during that 2.5 hours, during that day, during the Maya day, were her children her priority or her thoughts. She had a stroller with her that she could have strapped the boys in and brought them inside with her. You saw that in defense exhibit number 10. She knew what high temperatures could do to a body. And ladies and gentlemen, not only did she know what high temperatures and high fevers could do to a body, she knew what it could do to her children because she saw it happen to Mateo in the past. More knowledge of the dangers of what her actions could cause that day. She did not tell a single person that her babies were in the car. She told you she didn't tell people because she doesn't tell people her business. Well, ladies and gentlemen, she's chit-chatting for 2.5 hours. If you're really not telling people your business, you're not going to tell them that you're there to get butt injections. If you're really not telling people your business, you're not going to tell them in the first place that you have 2 kids. If you're not telling people your business, you're not going to sit there and talk about your 4th of July plans. If your life is that private that you don't want them to know anything about you, you sit there, you have your hands in your lap, and you are quiet. No need to participate. Or even more so, if your life and your privacy is that important to you, you wait in your car for your appointment. She didn't not tell people that her kids were with her because she was a private person. She didn't tell people her kids were with her because she knew it was wrong, she knew it was criminal, she knew that could get her in trouble. That is the only reasonable explanation as to why she did not tell the other patrons her kids were with her. It's the only logical explanation that she didn't tell the other patron her kids were with her. She didn't tell a single person that she was in a hurry. She didn't look at Shelby, Ian, or the 2 women on the couch. Hey, my kids are with me. Do you guys think I could jump your appointment? Hey, my kids are with me. I'm in a really big hurry. Would you mind if I went first? None of that. She didn't text the nurse and say, hey, I'm in a big hurry. How long is it going to be? Hey, can you get me in? I'm in a big hurry. What she did tell you was that she was blowing up the nurse's phone, essentially telling her she was late for her appointment and was in a hurry. This was a convenient line for the defendant to use until she learned that I had the text messages, that I had the entire conversation between her and Harmony that day, that I knew, and I could point out to you, the jury, that she did not mention one single time being in a hurry. The closest she got to that was asking at 1:59 if her appointment was still on, and then stating that her appointment was supposed to be at 1:30. Instead, at 1:11 p.m., she sent, or I apologize, 1:10 p.m., she sends a picture of the building asking if she's in the right place. 1:11 p.m., Harmony responds, yes, hon, go ahead and wait in your car till the time. We're a little backed up, my apologies. 1:12, okay. 1:34, do I go in now? 1:54, again, defendant reaches out, hey girl. 1:59, is my appointment still on? 2:02, yes girl, come in for paperwork. 2:03, is it the room I just took a picture of under the 31? That's defendant. 2:04, Harmony, let me see. 2:47 p.m., I'm in here, I signed the paper, but my appointment was at 1:30. This statement, ladies and gentlemen, does not say, I need to go right now. This does not say I'm in a hurry. This does not say how many people are ahead of me. This does not say, hey, Harmony, my kids are in the car. Can you speed this up? Can you get me in? Just simply says, I'm in here. I signed the paper, but my appointment was at 1:30. 3:11 p.m. Harmony says, hey, hon, what are you planning to get done? You just gave a deposit. I apologize for those typos. 3:11 p.m. BBL, the defendant responds. 3:12 p.m. defendant, I did the deal for the payment plan. $350. Okay, for $350 or $315, defendant Harmony says, okay, the $350 for $600 question mark. $316, the defendant says yes. Again, in this time period between $139, $140 and $316, there's no mention of, hey, I'm in a hurry. Do you have an estimate? Hey, we've been texting. Can I go wait in my car and can you text me when it's time to go? My kids are with me. You don't see any of that, ladies and gentlemen, because that didn't happen. $327, defendant. But they said they would add $50 to the BBL and then another $50 because they rescheduled me 2 times. 3:33 p.m., Harmony. Okay, that's fine. You're next after my client's mom, hun. 3:33 p.m., she knows it's going to be another 20 to 40 minutes. And she continues to sit in the chair. 3:34 p.m., thank you with a question mark. 3:35 p.m. from Harmony. No, OMG, thank you for your patience. Thank you for your patience, Maya Hernandez, as your children are sitting in your car burning to death. None of this conversation, ladies and gentlemen, reflects any intention of I was blowing her up to let her know that I was in a hurry. Again, another lie the defendant tried to tell you. The defendant told you that Harmony was lying when she said the defendant told her that her phone was in the car because it was dead. What incentive, what reason does Harmony have to be untruthful about that? On the flip side, what incentive, what reason does defendant have to tell her that her phone's in the car because it's dead rather than my phone is in the car because my kids are in there? Every incentive, because telling her that her kids have been in the car is her confessing to what she knew was a crime. Her confessing to something she knew was dangerous. Then she starts telling you she did not know it was bad to leave her kids in the car before she did it, only after. Completely inconsistent with her prior statement to Detective McNabb. Did not know it was dangerous to leave her kids in the car before she did it, only after. Didn't realize that detectives were asking her about what she knew beforehand. And then she says, I was just trying to take accountability. I was trying to take accountability for what I did. And ladies and gentlemen, you now know from her testimony and from her actions that when she said, I was just trying to take accountability, what she meant was, I was trying to take accountability until I realized just what taking accountability would mean for me. Again, thinking about Maya. I was just trying to take accountability, and now here I am facing murder. That was a little bit more accountability than she thought she was signing up for. That was a little bit more accountability than she thought she was accepting when she made those initial statements to Detective McNabb. And you have those statements. We've already talked about them. But again, ladies and gentlemen, as I've been telling you, you are going to have to ask yourselves, what did she know and when did she know it? Those answers are going to come from her statements and her actions. Have you heard the radio ads about not leaving your kids in the car? What did you think could happen if you do leave them? Prior to this happening, did you understand? She answers in the affirmative. Yes, I knew prior to this happening. These are very clear questions, ladies and gentlemen. These questions were not random questions that Detective McNabb just came up with. You heard Detective McNabb. He is a seasoned detective. He knew the answers he was looking for, and he knew the questions he had to ask. He knew he needed to get the answers that she knew beforehand, she knew prior, which is why you hear it worded the way it was. Like, prior to this happening, did you understand? What did you think could happen? What happened, I guess? What happened to Emilio? Question mark. Did you know that prior to this happening? Not do you know that now? Not do you understand that or recognize it now? Did you know that prior to this happening? And she talks about having seen the news, having heard people, knowing it in general. She knows that it is wrong. She knows this in general because as you heard from her mouth, as you heard from Dr. Masako, she is not an idiot. She knew it was wrong. She told you she knew it was wrong. Did you think about that when you were getting out of the car? Yeah. There is absolutely no way, ladies and gentlemen, to misunderstand this sentence as being something that was referring to what she understood in that moment. Did you think about that when you were getting out of the car? Yeah. I mean, if you knew that and you thought about it, what made you think it was okay to leave him? I don't know. She didn't say right here, I thought it was okay to leave them because I didn't think it was dangerous. She did not say, I thought it was okay to leave them because I did not think it was wrong. I don't know why I did it because I knew it was wrong and I knew that beforehand. The questions were clear, the answers were clear. And these, ladies and gentlemen, are the answers that you need to make your decision during your deliberations. So let's talk about the defendant's interview versus her in-court testimony. During her interview, she knew what she did was irresponsible. She knew what she did was irresponsible before she left the kids in the car. She knew that leaving the kids in the car was dangerous. She knew leaving the kids in the car was dangerous before she made the decision to do it. She knew what happened to Emilio could happen if you leave kids in the car, and she knew that before she decided to leave the kids in the car. She knew the dangers of leaving kids in the car from hearing people talk about it. Now, ladies and gentlemen, consider the circumstances that those statements were made under. She knew something bad happened to Emilio. I apologize, this says Mateo. She had not been charged with any crimes yet. As she's sitting there with Detective McNabb, she does not know she's facing murder charges. She's not been charged with murder. She did not have a lawyer yet. She did not know the elements to murder. She didn't know the difference between murder to manslaughter to child abuse and neglect. She didn't know this case would revolve around what she knew and when she knew it. All she knew is something bad happened, they're asking me questions, I'm answering, I'm thinking I'm taking accountability. So let's talk about how that changed when she got to court and the circumstances yesterday. In court, she says she didn't know it was dangerous until after the fact. Must have misunderstood what the defendants were asking her. Well, ladies and gentlemen, that statement alone tells you you got to ignore everything she said about that. Must have misunderstood. You saw the questions. You heard the questions. They were unambiguous questions. Didn't realize they were asking her about her knowledge before the incident. Prior to getting out of the car, prior to the incident, when you got out of the car, were you thinking about this? Those are not confusing statements, ladies and gentlemen. Was only saying that she knew it was dangerous after the fact. So let's talk about the circumstances that she made those statements under, ladies and gentlemen. She made those statements to you on December 15th, 2025. She made those statements to you during trial. She made those statements to you after she watched the entire trial. Opening statements, evidence. She made those statements to you after she had an attorney. She made those statements to you once she saw the people's opening, my opening, where I outlined to you everything required for second-degree murder implied malice, where I outlined that implied malice requires that she knows the actions are dangerous to human life before acting and did it anyway. She made these statements after she had that information. She made these statements in court after she heard her attorney say, just convict her of involuntary manslaughter. She didn't have the requisite knowledge. She made those statements yesterday after she knew that this case, that the difference between involuntary manslaughter and murder is going to rely solely upon what she knew and when she knew it. So now, ladies and gentlemen, you take all of those factors, the inconsistencies, the reasons that she has to lie, compare all of that to 226, compare all of that to her prior statement. And the only thing that you're going to be able to do is determine that you have to ignore those statements because they were lies. They were made up to support her case. They were made up to help fit with the law as she had learned it by the time she made that statement. The reliable statements as to what she knew and when she knew it are the statements that she made the evening of June 29th, 2025, and during the day on July 3rd, 2025. So again, second-degree murder. The defendant committed an act that caused the death of Emilio. When the defendant acted, she had a state of mind called malice aforethought. She intentionally committed the act. And I think, ladies and gentlemen, you're going to find that this element's not going to be very contested by the defense. This element is also required for involuntary manslaughter. The natural and probable consequences of the act were dangerous to human life in that the act involved a high degree of probability that it would result in death. The act did not have a high probability that it would result in death. The act did result in death, ladies and gentlemen. The act in itself, leaving kids unattended in a car for 2.5 hours, has a high likelihood that death will result, and in this case it did. At the time she acted, she knew the act was dangerous to human life. I knew what happened to Emilio could happen if I left them in the car. I knew it was irresponsible to leave them in the car. I knew what could happen to Emilio could happen, and I knew that before I left him there. I knew it was irresponsible to leave them in the car, and I considered that fact before I got out of the car. She deliberately acted with conscious disregard for human life. This means she knew the consequences, she knew the dangers, and she did it anyway. She knew it was dangerous to leave them in the car. She knew what could happen if she left them in the car, but she did it anyway. Failure to protect. The defendant had a legal duty to protect Emilio, and the defendant failed to perform that duty, and that failure caused the death of Emilio. When the defendant failed to act, she had a state of mind called malice aforethought. Implied malice, again, she intentionally committed the act. The natural and probable consequences of the act were dangerous to human life in that the act involved a high degree of probability that it would result in death. Again, same elements. At the time she acted, she knew it was dangerous to human life. Those same statements from interviews 1 and 2 apply to this, ladies and gentlemen. She deliberately acted with conscious disregard for human life. She knew it was dangerous. She did it anyway. Again, malice aforethought does not require hatred or ill will towards the victim. It's okay that you heard that she loved her children. It's okay that she got emotional talking about the death of Emilio. It's okay that you saw the photographs of them at the pumpkin patch at the beach. She doesn't have to have ill will. She does not have to want Emilio to die. That is not a requirement for implied malice second-degree murder. Involuntary manslaughter. Again, the defendant committed a crime or a lawful act in an unlawful manner. The defendant committed the crime or act with criminal negligence. This is going to be one of the main differences. Criminal negligence versus implied malice. The defendant's acts caused the death of another person. A person acts with criminal negligence when he or she acts in a reckless way that creates a high risk of death or great bodily injury, i.e., leaving your 2 babies in the car for 2.5 hours so you can get a butt lift. And a reasonable person would have known that acting in that way could create such a risk. The difference between second-degree murder and involuntary manslaughter, ladies and gentlemen, is simply, what did she know? Not what should she know, because everybody knows it, but what did she know? And the law actually tells you that. Specifically says the difference between second-degree murder and involuntary manslaughter depends on whether the person was aware of the risk to life that her actions created and consciously disregarded that risk. That's the difference, ladies and gentlemen, between second-degree murder and involuntary manslaughter. And you have that answer from her statements to Detective McNabb, Interview 1 and Interview 2. You also have that answer from many of her actions. Not telling anybody her kids were in the car, not going to check on the kids, not knowing for certain whether or not her car would stay on. She knew. This difference, ladies and gentlemen, is met. This is not a case of involuntary manslaughter because of her knowledge. Her statements that she knew what could happen to Emilio could happen. Her statements that she knew it was irresponsible and she acted anyway. Her statements that she knew what could happen to Emilio. And by the way, ladies and gentlemen, remember when you're considering that statement was made after she learned Emilio had passed. Her statement that she knew what happened to Emilio could happen and she knew it beforehand. And that she knew these dangers in general from hearing people talk about it, television ads, radio ads. Those statements, that knowledge is what gets you from involuntary manslaughter to second-degree murder.